Alex here with part 204 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my efforts to have my ex served by publication. It's a pretty detailed, or there is a video that goes into the details of a service by publication. And if you want to learn more about that, I would say please take a look at my video on the topic, service by publication. I will state that this did not affect my mindset. The inability to find my ex was not frustrating because before I had even filed the petition for termination of parental rights, I already suspected that I wasn't going to be able to find her because, I mean, the whole time, the 8 years, she never, let us know where she lived. So she'd already dropped off the face of the earth. Nobody knew where she lived or worked. And so going into this petition for TPR, I already expected that I was going to have to do this. There was one thing that I wanted to mention. Yes, my insight was so keen on this issue that I remember when I filed the petition, the clerk asked to set it to like 2 or 3 weeks out. And I was like, no, I'm going to need more time. Don't set it out 2 or 3 weeks. We're going to need to set this out 2 months because of the publication process. And so the clerk set the hearing out longer than usually they would for a TPR because of precisely that. I asked them, and I knew I was going to need more time to go through the publication process because there are just inherent delays in that process with regards to how long something has to be in the paper and all that stuff. So that handles the mindset portion of video. All that being said, let's go ahead and take a look at what I have filed. Here we have the motion for publication. Let's see. I noticed that there is no. Okay, yeah, Notice that I'm not asking for oral argument. The reason why is because I don't really think the court needs to take evidence on this issue. From my research of service by publication, the court makes the decision based on certain affidavits and declarations. I think they can set an evidentiary hearing, but if it does come up, my understanding is that it comes up later on if somebody tries to set aside a default or a judgment in a case, arguing that publication was improper for some reason. Usually that is when they will set it for an evidentiary hearing and really get into the issues. But my understanding is that they will typically just trust the movant who's requesting service by publication. They'll typically just trust him based on the declarations. There's quite a few declarations that have to get filed. They call them declarations of due diligence, and usually it involves more than just one person trying to locate the target of the lawsuit. But in any event, I just wanted to mention that. Standard introductory paragraph indicating that I am appearing in proper person, which means I'm representing myself without an attorney, that I filed a motion for publication, and that it's based on the following points and authorities. Parties share a common child of age 9. Okay, so we've seen this This is just the generic sort of summary of what's going on. Child is age 9. I have primary physical sole legal custody. My ex has supervised visitation. No, wait. She has suspended visitation. That's right. She has suspended visitation. Service by publication is necessary and appropriate because we can't find her. So we got a factual background here. On August 26th, the court ordered my ex to, within 30 days, obtain and provide me with a fictitious address issued by the Confidential Address Program. On September 21st, my ex obtained a fictitious address from the Secretary of State. On April 25th, I sued, filing an original writ petition challenging the Secretary of State's issuance of that address to my ex, which triggered an expansion of Nevada case law, and that is a case that's named after me, Falcone v. Secretary of State. December 24th, 2013, the court entered a writ of mandamus directing the Secretary of State to disclose my ex's actual physical address to me. On January 2nd, 2014, the Secretary of State did as they were ordered to do. They disclosed that address to me. This is an old address, guys. She's definitely not there anymore. It's ancient history. On January 22nd, 2016, the court entered an order regarding omnibus motion, ordering my ex to, again, disclose her physical address and suspending her in-person visitation for violating that, I was going to say order, but it's plural. I don't know how many times she's been ordered to do that. February 24th, 2016, the district attorney's process servers failed to locate my ex. That's why they vacated that first order to show cause hearing they set against her. On June 1st, 2016, I contacted my ex's aunt and uncle to inform them that I was in the process of terminating my ex's parental rights to clear the way for adoption. What do we got here? I also contacted my ex's brother. I also, asked where he responded. Okay, so hold on. We have some responses here. Sorry. Well, I guess we have the responses in the exhibits. So we'll go over their responses when we get to the exhibits. Never mind. I also contacted my ex's husband. Let's see here. Okay, so that's another exhibit, guys. There's going to be several exhibits we're going to go over with that have these details. And then I also contacted 3 of my ex's former exchange designees. On June 1st, 2016, I executed a series of background checks on my ex, which the only promising information gleaned was a residential address in Hawaii. On June 2nd, I filed the instant petition for termination of parental rights. On June 3rd, the district court issued and filed a notice of hearing. On June 4th, first process server failed to effect service of process at my ex's former residence after confirming she no longer lived there. On June 7th, same process server failed to effect service of process on my ex's former place of employment after confirming she no longer worked there. On June 8th, we have another process server who failed to effect service of process on my ex's husband's residence after confirming that she no longer lived there. Former investigator for the Attorney General performed an additional skip trace, and that didn't help. So we go into the legal analysis here. The filing of a petition for termination of parental rights triggers the clerk's issuance of a notice of hearing, and the law provides that publication of the notice in the newspaper is appropriate when, and basically it's when the mother of a child resides out of state, has departed from the state, or cannot, after due diligence, be found within the state, or conceals himself or herself to avoid the service of the notice of hearing. And the fact appears by affidavit to the satisfaction of the court thereof, and it appears either by affidavit or by a verified petition on file that the named mother is a necessary and proper person. Of course, she's a necessary person to the proceedings because she's the natural mother of the child. So my ex has stubbornly refused disclosure of her residential address since 2008. It's been 8 years, and the situation has worsened in that her recalcitrance has resulted in a suspension of her visitation rights. My ex has not been in communication with her own friends and family for several months, despite her brother and grandparents having reached out to her. Next, we have, aside from the filing of several affidavits that are in technical compliance with the rules, I have been mindful that my actual efforts as a matter of law must not fall short of the due diligence requirement to the extent of depriving my ex her fundamental right to due process. It's a little wordy, but what I'm trying to say here is that just because there are court rules that outline how I can go about service by publication, I still have to comply with certain constitutional principles directly connected to the due process. What do they call it? The Due Process Amendment. I know there's I think it's like the 14th Amendment or something like that. In any event, I'm trying to say, and this is the case that I cited, Price v. Dunn, because in this case, Price v. Dunn, it's very on point. They go over a termination of parental rights that was served through publication, and they mention in that case that even though you can comply with the rules on publication, you still have to go above and beyond, and you have to do more than just what those rules say to try and locate them. And that requirement, specifically the complaint the Supreme Court had in that case, was that the individual reached out to family members, but the individual only asked, hey, do you know where they live? They didn't say why. And my suspicion is that the Supreme Court felt that they kind of deliberately didn't want to be told where they lived. They kind of deliberately wanted to proceed with publication. And the Supreme Court said that really, they should have stated, do you know where such and such lives? Because I am trying to terminate their parental rights. And the Supreme Court reasoned that in Price v. Dunn, had they said that, had they reached out to those people and said, hey, I'm trying to terminate their parental rights, they may have given them a different answer. They may have said, we're not going to just assume that she's hiding from this person and doesn't want to talk to them. This is a big deal. They're about to lose their parenthood of their child. And they may have said something differently. They may have said, hey, why don't you, give us that piece of paper, or, give us the case number, we'll reach out to her. And so that's what Price v. Dunn goes into. And so I made sure when I reached out to her friends and her family members and all that, and you'll see that when we go through the evidence, the exhibits, I made sure when I reached out to them that I didn't just say, hey, do you know where Monica is? I made sure to say, hey, do you know where Monica is? Because I am trying to terminate her parental rights, and it's very important. So we'll go into that in a second. Accordingly, I'm requesting an order directing the publication of the petition and notice be made in the Honolulu Star Bulletin for a period of 4 weeks. And the court will order publication. So this is a motion that I'm going to win. But instead of ordering that the publication occur in Honolulu Star Bulletin, they're going to order that it occur in Clark County. Conclusion. Therefore, I request that the court direct the publication of the petition. Verification. So, yep, as with before, I swear under penalty of perjury that all the facts alleged in this motion are true and correct. List of exhibits. We have quite a few. We have court order, a writ of mandamus. We have quite a few things I'm going to skip over. So we have an order, a writ of mandamus, and another order here, and a court calendar vacate sheet. I know that I've already gone through those in the My Docket series. My standard policy is to not go over the same document twice in the My Docket series. If you've been following through the series, then you would have seen my analysis on those documents anyway, so you're not missing anything. But I will go over these letters. So it looks like we have a letter, and it looks like some Our Family Wizard messages, possibly, maybe. Let's go ahead and get down into these exhibits. So this is the order we've already seen. This is a writ of mandamus. And again, I don't know if I mentioned this, guys. Anytime I skip over a document, keep in mind, you can still yourself go down into the description below, click on the links, download it for yourself. And if you see something in that particular area of the document, just let me know down in the comments below. It looks like a letter from the confidential address program officer indicating that my ex's confidential address was canceled. And we have another order. This is the one that suspends her in-person visitation. Already gone over it, guys. Okay, Exhibit 5. What is this? Okay, we've already gone over this as well. This is the one that cancels her order to show cause hearing. Okay, here we go. It looks like, okay, this is a message to aunt/uncle. I think they share a phone. And so here I mentioned, hey, we are filing a petition to terminate her parental rights so Brittany can adopt him. So you can see that I've been very clear about what we're doing. And then let's see. They respond. The grandparents, who probably won't respond if you ask them, nor have we heard from her last October. So they've responded. So they might think that I'm reaching out. I mean, in a way, I'm trying to be polite, but they probably don't understand that this message was given with the intent to be included as an exhibit in a motion for publication. So from their perspective, they're just answering my question innocently. But the question itself was asked very strategically in the sense that it had to be consistent with the law, more specifically with due process rights. So this is the brother. Let's see. Talking a little bit about code. He's also an engineer, software developer. It looks like he's asking me about his inability to find her. So he's asking about process servers and how to locate her and stuff. They were worried about her, guys. Remember, they filed a missing persons report. The report's since been closed. I think I've mentioned this to you guys, but they closed the missing persons report because she was paying child support. So, I mean, she was fine. She just didn't want to be found. Where's the question? Do I ask the question here? Maybe I'm just using this to show that even he can't find her. This is showing that he's trying to find her and that he can't find her. All the different sites that he's using to locate her, the case numbers he's asking for. So I guess I just use that in the general sense. Okay, let's see, what is this? Okay, oh, this is the husband. Okay, so this is me telling him my intention, and I figured that if she was still with him, that I figured he wouldn't respond, but I figured that what he could do is send this message to her to let her know what I'm about to do, and I don't think he responds. No, no response. Okay, and then we have here a message to my ex in our family wizard, which she hasn't opened since forever. And this is just telling my ex in the message, I'm in the process of adopting him to Brittany. Let me know the new address. And of course, she doesn't respond. This is directly sent to her phone. It looks like a text message. Same thing. I didn't expect a response. This is one of her friends and designees. A designee is like an exchange designee, somebody that can come and pick up the child at an exchange rather than the actual parent. Same message that I sent to the aunt and uncle. And I figured he wouldn't respond, and I figured that if he was still friends with her, he would find a way to get the message to her. Let's see, Robert Burr, same thing, another friend, another exchange designee, same message. I don't think he responds. Nope, no response. Okay. Then we have the affidavit for service by publication. This affidavit is prepared by me. I'm indicating that, let's see here, my ex is the living natural parent or mother of the child and that she's a necessary party to the action. My ex resides out of state, was last known to reside at the following address, and that I don't know where she lives anymore, and that my efforts to make contact with her have failed. Next, we have another affidavit of due diligence. This one is from the process server in Hawaii. He's stating that he's not a party to the action, that he's the owner and operator of the company Aqua Legal, that he used to be an investigator for the Massachusetts Attorney General, that he is engaged in service of process, that he ran a background check on my ex, and let's see here, was unable to find any current information on her whereabouts, and that he has attached the results of his background check as Exhibit 1. That's cool. I didn't know that he did that, or I forgot that he did that. So this is just his efforts to locate her. This is the same stuff that we found when we ran stuff online. Same stuff. And then we have, let's see, affidavit of due diligence for Megan. So this is the other process server that was in Reno. Let's see, June 4th, 2016, attempted service of the petition for termination of parental rights. And then, of course, she would have gone to the address turned over by the Secretary of State. And it looks like her place of employment at the VA hospital. So both of those attempts failed. And that's it. Going into the aftermath, I filed, it looks like 1, 2, 3, 4 documents, but they were all free filings, so I incurred $0 in costs. My ex didn't participate in the proceedings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex likewise didn't have an attorney, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.